Good day to you and welcome to another Paddocks Club video tutorial. Today I'm going to concentrate on the Sectional Title Schemes Management Act, number 8 of 2011, where we expect the regulations to be published shortly. That of course will lead to discussion, but before we can start sensible discussions on the club or elsewhere, you need to know the fundamental changes that have been made under this act or will be made when that act is brought into operation. The full text has been up on the site for some time, but this is now a quick and dirty overview highlighting only the major innovations as I see them, so that you can have these in mind when reading the draft regulations and commenting on them. The fundamental purpose of the Sectional Title Schemes Management Act is a reenactment of scheme management issues in more logical sequence. They will all of course be simultaneously removed from the Sectional Titles Act, but in the process there have been changes, and that's what I'm highlighting. Firstly, in the definitions, there are many more. Some of them deal with the CSOS, some of them deal with the new advisory council, but there are no major changes. Bodies corporate dealt with in section 2, again, no major changes. The functions of bodies corporate under 3 are the reworked section 37. In addition to an administrative fund, each scheme must have a separate reserve fund, with the minister prescribing minimum amounts for those funds. Annual and special contributions can now be recovered, or must now be recovered, by application to the CSOS rather than to the magistrates or High Court. And the Community Scheme Ombuds Service takes over the role of the Chief Registrar of Deeds in regards to many aspects, such as notifications, keeping the rules, examining them, all that sort of thing. 4 deals with powers of body corporate, and what's new is that special resolutions of owners are required before the body corporate can acquire, mortgage or let or dispose of units, before it can borrow money, and before it can let parts of the common property on a short-term basis to owners or occupiers. Under 5, which deals with additional registration-related powers of the body corporate, there are no changes. It's just an aggregation of all those registration-related powers in one place. 6 deals with meetings of the body corporate, and here there are some innovations. A person may hold only a maximum of 2 proxies. When owners vote in number, they only have 1 vote per member. And a body corporate or an owner can apply to the CSOS for a unanimous or special resolution if they've got good grounds for that. 7, 8 and 9, no major changes. That's dealing with trustees of body corporates, their fiduciary position, and the proceedings on behalf of bodies corporate, which can be made still by application to the High Court if the body corporate fails to take action in something in which it has a right, and the owner wants to take that up. 10 deals with rules, and you should look at that. There's a body corporate obligation to keep copies of all the rules, to distribute them to owners and occupiers, and also to bring them to meetings. There's also the reintroduction, importantly, of the obligation now on the CSOS to examine the rules that are lodged for filing to ensure that they are in order before they become filed and effective. 11, 12, deal with the effective participation quotas, variations, expropriation of common property, no major changes in principle here. 13, duties of owners. Well, owners must advise the body corporate of any change of ownership or occupancy in any unit, as well as every time they mortgage, as is the case now. 14 and 15 deal with insurance by owners and recovers from owners of unsatisfied judgments. No changes of any major import here. 16 is a more detailed treatment of the administration by an administrator appointed now by a magistrate's court rather than the High Court, and an obligation to hold owner and trustee meetings. More detail there if you're interested in administration. 17, destruction of damage or damage to buildings, not any change in principle. And then 18 deals with the Sectional Title Schemes Management Advisory Council, 19 with regulations, and the rest are just the tail enders. 20, 21 and 22 are just the final detail amendments to the Act, transitional arrangements and short title and commencement. So that's your very quick overview. For more detail and for an increasing body of comment on the Sectional Title Schemes Management provisions, please look under Acts in the Paddocks Club forums. Thank you.